This is the big one we talked about yesterday when you previewed the final day that we'd be watching for. Any surprises in either the decision or the vote here?
I think there are a bunch of surprises here. I mean, there are 194 pages worth of some surprises here, Willie. Let's start with Justice Kavanaugh, who stakes out a ground here that I think was not well anticipated by the oral argument. He's essentially siding with majority, as you just noted, but not on constitutional grounds. I was explaining last night Justice Kavanaugh's reasoning to some of our colleagues in the elevator, a bunch of 20-somethings who work in the newsroom, and they looked at me so quizzically, and I said, that is the plainest I can explain it, and if it doesn't make sense to you right now, it doesn't make sense to me either. So let me try to explain to our viewers. Justice Kavanaugh saying the citizenship clause of the Equal Protection Clause doesn't foreclose Trump's executive order forbidding birthright citizenship to certain people, but a statute that uses almost identical wording does. And you might be wondering, how is that possible? He says that's because the statute was enacted after the Supreme Court's last case on birthright citizenship, which carved out a number of sort of exceptions and admitted of no others. And he says because of that, we should interpret Congress to say there are only a few instances in which people born in this country aren't citizens. And if Congress wants to change it, that's up to Congress. How he can take, though, almost identical wording in the Constitution and a federal statute and interpret them differently might leave a lot of people scratching their heads, particularly when he all but invites Congress to change the law if they feel differently. The other big, though, surprise here is Justice Alito, who does dissent from the decision, but also says birthright citizenship in the Constitution is a floor. It's not a ceiling. And we have humanitarian issues in this country presented by those people who are not yet citizens. So according to Justice Alito, if you want to change the composition of who counts as a citizen in this country, that too is up to Congress. So on one hand, you've got Justice Kavanaugh saying, if you don't like who's a citizen, you can limit it. And on the other hand, you have Justice Alito, who also disagrees with the majority's ruling on the Constitution, saying, if Congress wants to confer citizenship on more people in this country, it has the latitude to do so, and maybe it should do so. And so in both respects, big surprises here. Other big surprise, big debate between Justices Thomas and Jackson about who is meant to benefit from the citizenship clause of the 14th Amendment. Justice Thomas believes that it was really intended always just to help the citizens of slaves, but says it was never meant to confer citizenship on people who are temporarily here or unlawfully here. Justice Jackson really taking a big issue with that and says the fact that we have consensus about what the central motivation of the 14th Amendment was doesn't justify, and I'm going to read here her words, Justice Thomas's myopic treatment of it, that the whole point of the 14th Amendment was an anti-caste, anti-subordination reset, not a mere spot treatment for the dark stain of slavery. In other words, don't you dare use the experiences of Black Americans to drive a wedge between us and other people in this country who want to be here and should be here by virtue of the Constitution.
This obviously has been an obsession, perhaps, of President Trump for some time now, getting rid of birthright citizenship. Now it becomes, I think, a political question, as the justices said. If you want to change this, go to the Congress. Speaker Johnson said, condemn the decision. You heard J.D. Vance condemning the decision. Even some of the justices talking about birth tourism,
right?
That this just encourages people now to come here, have a baby, and move along. Again, those are our political questions. But I guess one of the big questions a lot of people have is this has been in the 14th Amendment for all these generations. Why now this sudden almost revelation by some people that, oh, my God, this is a terrible thing?
Well, I think part of it is what they see on the ground, right? This documentation, at least according to the conservative legal movement, of birth tourism, which came up at oral argument. And there was an exchange between John Sauer, the Solicitor General, and Chief Justice Roberts, where John Sauer basically said there are 8 billion people in this country who are a plane ride away from being birth tourists and therefore giving citizenship to their country. And John Roberts' retort to that was, well, it's the same old Constitution, Mr. Sauer.
Right.
But I think the other thing, and this is sort of like zooming out and looking at the Trump administration writ large, this is an administration where what used to be fringy theories about how to interpret the Constitution suddenly fall into the mainstream. So we think about the unitary executive theory, which used to be something that nobody really talked about, has definitely been pushed to the forefront of their legal agenda. Similarly, some of the ideas that motivated January 6th and some of the legal strategies underpinning it, things that people like Ken Chesebro and John Eastman were propounding, those were things nobody talked about until they started talking about them. And now all of a sudden, they have major currency within the Republican Party and certain facets of the conservative legal project.
What is the interior executive theory?
The unitary executive theory is essentially an all-powerful executive that gets to consolidate all sorts of powers in the executive that we might have thought about and other times as more equally balanced between the three branches.
It's interesting that the lives of so many people, people not yet born, people who are here now, came into conflict in the court this week. You get temporary protected status rulings. You have the 14th Amendment that we're talking about. It's just interesting. All of these people, most of these people, I would assume, are living right on a very thin line.
I think that's absolutely true. And I think it also speaks to sort of the multifaceted approach of this administration to solving what they perceive as policy problems. So, right, if you're thinking about the policy problem being undocumented immigration to this country, they have attacked it in all sorts of ways through a birthright citizenship executive order that's now been found to be unconstitutional, but also by cutting off temporary protected status to people from all sorts of countries, by starting these waves of crackdown on undocumented people in cities all throughout the country. It's not just that they choose one door to open. It's literally, as our colleague Chris Hayes once said to me in a similar context, it's like they go down the hallway of a hotel and they kick down open every single door that they can to get at a problem that they believe exists and should be eradicated.
The president saying yesterday in a post, the decision is too bad for the country, but that it will be, quote, easily fixed through Congress. It won't be so easy, but he certainly will try. Meanwhile, the Supreme Court also struck down longtime rules that place limits on just how much national political party committees can spend in coordination with candidates. It was a 6-3 decision there. The court ruled the Federal Election Campaign Act, enacted in 1974, violates the First Amendment rights of political parties. Republicans, including Vice President Vance and the National Republican Senatorial Committee, brought the challenge to court. Justice Brett Kavanaugh wrote the majority opinion, which reads in part, in short, constitutional text, history, and precedent established that the political party coordinated expenditure limits violate the First Amendment. This decision is expected to give Republicans a financial edge in the upcoming midterms because the party's committees have much more cash on hand than Democrats do and can deploy that money without being hindered by previous caps and limits. So 24 hours ago, when you sat with us, Lisa, you were looking ahead to this and saying, if this goes the way it looks like it might go, and it did, this will fundamentally change money in politics. And here we are.
Absolutely. And it will be the death, I think, of the independent super PAC and the rise again of party apparatuses. And if you're a major donor in this country or somebody who bundles and you're thinking about where to give your money, in excess of sort of the individual contribution limits right now, all of a sudden the major parties became a much more attractive place to spend it. I will also say it's a huge advantage for the RNC. While the Senate committees and the House committees of the Republican Party have a cash edge over the equivalent on the Democratic side, the amount of cash on hand for the RNC overall compared to the DNC is staggering. The DNC is in debt. The Republican National Committee carrying over $100 million right now in cash on hand. So going into this next midterms election cycle with this decision in hand, this is not a good place for the Democratic Party and its subordinate committees to be.
So how does it affect the flow of money and the flow of contributions?
Well, I think one of the concerns that the dissenters have, Mike, is that what it will do is basically allow people to circumvent individual limits by giving well in excess of what you could give to a candidate by giving it to a party committee. So right now, individuals can give over $100,000 to a party committee. It may be that because that party committee can now coordinate with a candidate, if you really want to donate to Mike Barnicle, you may have incentives to do so through his party rather than through super PACs. I've heard people in the political sphere say that this maybe doesn't affect the overall sum of money in the political system, but rather where people are giving it and who has control of it. Right now, the chair of the Republican National Committee, I understand a man named Joe Gruters, and I apologize to him and our viewers if I've mispronounced his last name. He's probably the happiest person in all of Washington right now.
Yeah, and you could pair this with the 2010 Citizens United decision as well. Just one more step in the dismantling of campaign finance laws in the country. One more, the Supreme Court also decided to uphold two state laws barring the participation of transgender female athletes from girls' and women's sports teams. In another 6-3 decision, the justices ruled against two transgender students who challenged restrictive laws in West Virginia and Idaho. In his opinion, Justice Kavanaugh argued the laws do not violate either the 14th Amendment or Title IX, but did to compete warrants respect, adding they should not be ostracized or vilified. Although the ruling directly concerns only West Virginia and Idaho, it is likely to affect 25 other states with similar bans. And isn't that one of the points here, Lisa, that this now will be used, interpreted across the country as effective ban on transgender girls in sports?
Absolutely. And that's particularly true, Willie, because one of the challenges or one of the questions that the two plaintiffs presented here was not just that the bans were unconstitutional writ large, but they said they're unconstitutional as applied to us because we could meet exceptions. There are reasons that because we didn't experience puberty associated with our biological sex, we took puberty blockers, that biologically we didn't go through the sorts of advantages that you traditionally might think of as associated with being born biologically female. In fact, it's not clear that we have any competitive advantage whatsoever. These states should be forced to look at us as individuals, and the court denied that as well. This is also a case where I think some cases you look at and you say the justices don't have any to bear on the court. This is one where it's unmistakable that Brett Kavanaugh, who wrote for the majority, is speaking of something that's deeply personal to him. He's the father of two daughters, both of whom are now college age, both of whom played high school athletics. And he talks about what the impact would be on women and girls in this country who play high school sports if the ruling had gone the other way. And he has this whole thing at the end about women and girls who play sports caring deeply about competition and making sure that every opportunity that they win is one that they get fairly